And I understand that the union has a statement they would like to make, so why don't we start with that? And then we'll allow other members of the public to speak. Oh, I'm sorry. First, we need to take roll call. I apologize. Terry?
Brewer. Here. Colantuno.
Here.
Corcoran. Here. Flanagan.
Here.
Fox.
Here.
Krinsky. Here. LeBron.
Here.
Lee.
Here.
Mangers.
Here.
Mendoza.
Here.
Myers.
Here.
Moore.
Here.
Stallings.
Here.
Stevens.
Here.
Vera.
Here.
Pasternak.
Here. Okay, now we'll start with the public comment from the union.
Thank you. We really appreciate the opportunity to address you, the Board of Trustees. We're here to speak on behalf of the State Bar Employee Union and specifically the employees of the Office of Chief Trial Counsel. I'm Erin Joyce. I'm a senior trial counsel in the Los Angeles Office of Enforcement and the Attorney Unit Vice President. With me is Brune. She's a senior attorney here in San Francisco and the Attorney Unit Vice President in the Northern California chapter. We, the State Bar employees, share a unity of interest with the members of this Board of Trustees and the new executive team. We all share the public protection interest and mission of the State Bar, which is threefold. We're here to protect the public, to maintain the highest professional standards, and to maintain the confidence of the public in the legal profession. Just as this Board of Trustees, starting its new year at the beginning of October, and this new executive team, which started in the last few months, all want to put the strife and controversy of the last year behind us, so too do we, the State Bar employees. It all started about a year ago with the determination of the former CEO. We careened into June with the scathing state auditor's report, which indicted the Office of Chief Trial Counsel in its work. More recently, we've been the subject of a whistleblower complaint. And we're here to talk to you about the unprecedented 76% no confidence vote of the State Bar employees of OCTC in a second term for the current Chief Trial Counsel. We all want to put this chapter of the State Bar history behind us. And we don't think putting Jane Kim in for a second four-year term is the way to do that. As I said, the State Bar employees, for the first time in their history, voted overwhelmingly, 76%, that they have no confidence in a second term for Jane Kim. Confidence means trust. Trust, which is a belief in the reliability of a person. And we resoundingly have no confidence in the current chief. The no confidence vote is based on a basic breakdown of trust between staff and the current management of the Chief Trial Counsel's office.
There is no trust in management's explanation for the Supreme Court kickback of stipulations. Staff does not trust management's explanation for the kickback stipulations from the Supreme Court. Jane Kim blames the kickback stipulations on the lack of supervision of staff. She actually blames it on the prior administration, saying she did not realize there was no supervision when she came on board in September 2011. There is no trust in that explanation. We estimate that over 2,000 cases were moved in approximately 3 months' time, an unprecedented number of cases with no increase in staff. We were well supervised at that time. The only mandate from supervision was zero backlog. Jane Kim abdicated professional protection in the interest of zero backlog.
There is no trust in Jane Kim's charging and settlement policies. As the direct result of Jane Kim's faulty interpretation of the lesson from the Supreme Court's remand, she has put a stranglehold on charging and settlement decisions. Everything has been centralized. The opinion of a management committee is routinely substituted for the decision of the line staff attorneys handling the cases themselves. This has resulted in cases that are routinely being overcharged, cases that are forced to go to trial, which should have settled, and as a result of that, there have been a string of stinging losses, outright losses in trial. more in the last 4 years than probably the last 10 before that. Line staff is not afforded any flexibility in settlement negotiations. The results are often harsh, rigid, and unrealistic settlement postures.
There is no trust in Jane Kim's timeframes that require all investigations to be completed in 90 days. Under Jane Kim's policies, every investigation plan must be completed in 90 days. This is pre-printed into every investigation plan, and every employee evaluation takes this time frame into consideration. There are lots of reasons why cases cannot be completed in 90 days, including basic administrative issues such that immigration records, court records, and trust account records often take 60 days or more from request to receiving them. Jane Kim has set 20 cases as the caseload optimal to meet backlog for each investigator. But caseloads are routinely twice that amount, up to 50 cases per investigator. Even with caseloads double the optimal amount, Jane Kim uses a disciplinary process, PIPs, to chastise investigators for not meeting timeframes. Investigators do not trust that Jane Kim is treating them fairly and is instead holding investigators and attorneys alike to unrealistic timeframes. Staff does not trust that these policies serve public protection. There is undue emphasis on timeframes at the expense of public protection. Investigators and attorneys alike want more focus on public protection, which includes devoting more time and resources to complicated, time-consuming cases that pose a greater threat to public protection and which cannot be completed in current backlog timeframes.
There is no trust that Jane Kim is giving RAD or this body an accurate picture of what the department can do with its limited resources. Now, regardless of who is held accountable for removing the state bar investigations from the backlog metrics back in 2013, and that we acknowledge is a completely separate issue, it certainly cannot be refuted that by removing those SBIs from the RAD reports starting in September 2013 through the end of that year gave RAD an inaccurate picture of what the department was doing. And the only person who benefited from that skewed picture was Jane Kim, who herself was facing her evaluation. And the end result of that was that RAD lacked an accurate account of what the office could do with limited resources. She made promises that were impossible to keep, and she claimed to have benchmarks which we know she did not meet. Now, in addition to claiming near zero backlog in 2013 and trumpeting getting to somehow zero in 2011, which both weren't true, she also claims credit for other things which don't make sense. She claims credit for an investigator mentor program in her October 2014 report to RAD, which only existed on paper. The two senior investigators that were approached right before that report went out about setting up that program heard nothing more about it after she trumpeted its success in that report. The same thing is true about her Phantom Law Enforcement Liaison program, for which she's greatly exaggerated its performance in RAD reports. But perhaps most egregious of all is her claim that our office is aggressively pursuing immigration fraud in the immigration community. In fact, when non-attorneys commit unlicensed practice of law preying on immigrants, the truth is those cases are routinely closed without any action. A competent chief trial counsel that was honest with this body and with RAD would accurately report that with our limited resources, it's about all that the state bar can do to take care of misconduct by errant attorneys. With limited resources and limited time, we just can't do everything. But instead of reporting the truth, she tells RAD and others that we're doing everything when we know those that are inside know that we can't and we aren't.
There is no trust that workforce planning is going to solve these problems. Although we're looking forward to addressing workforce planning, this does not resolve the fundamental lack of trust that we have described. We want a chief trial counsel who will restore the credibility of the office with impeccable integrity. A chief trial counsel who will take accountability for her own policy decisions, not blame them on employees, especially low-ranking administrative support staff. A chief trial counsel who has a realistic picture of what we can do with our constraints of time and resources, and who will accurately report this to RAD. A chief trial counsel who places public protection as the highest value, and who appropriately allocates resources and attention and prioritizes goals instead of making promises that can't be met. And a chief trial counsel who recognizes the intelligence and decision-making abilities of employees and treats them with respect. It does not bode well for the next 4 years to have 76% of employees who do not trust their chief trial counsel. And make no mistake, the voters included new as well as older employees. To protect the public protection functions of bar, we urge you to select a new chief trial counsel. We're here to let you know that we have no confidence in this chief trial counsel.
Okay, thank you for your comments. This matter is not on the agenda today. However, because of the union's desire to make this presentation to us, we did allow them to make this public comment. I am certain that when we do consider the appointment or reappointment of chief trial counsel, that this board will consider all the information that is presented to us and which we are aware. So thank you. Is there anybody else who has public comment on any of the matters on our agenda today?
Yes, sir.
Yes, would you please identify yourself?
Yes, my name is Carmen Cave, and I am a law student and intern with the Center for Public Interest Law down at University of San Diego. And I wanted to comment on the draft